Welcome everybody to the fourth and final day of our Terrorism and Belligerency workshop. It's been a very interesting first 3 days, and I think we're looking forward to the interesting presentations we have today. As always, and in each session we have some new faces around the table. We're going to start with introduction around the table. I'll just note that today was final day. We're gonna have dinner at Caesarea. So when we're gonna finish here at about 4:30, we're gonna drive to Caesarea, and hopefully we're gonna be there in enough time to look around at the area and to view. It's very interesting, very beautiful place, and then we're gonna go to dinner over there. So let's start with the round of introduction. You're always the first. Let's skip that tradition.
There's absolutely no fairness in this world. Hello, my name is Ira. I'm a PhD student at UCL. Me?
Yeah, last time it was longer. Last time it was more quick.
It goes.
Okay, I'm Michal. I'm the coordinator of the center.
I'm Anu, and I'm a PhD candidate at City University.
I'm Robert. I'm a PhD candidate here at Haifa.
I'm Hadas. I'm a visiting researcher at Davis Institute and at University.
Eli Salzburger, and the director of the Minerva Center and member of the faculty of Prof.
My name is Alman Reichman. I'm also a PI at the Minerva Center, and I teach constitutional and administrative law here at the University of Haifa.
Barbara Reporter, I'm a PhD candidate in political science at the University of Kansas.
Dean Prof, faculty member of the University, International Criminal Law.
There wasn't slide, director of research here at the Minerva Center of Terrorism and Belligerency, and a PhD candidate with the University.
I'm Hickelman, I'm a PhD student still at University. I'm a researcher in the
Robert Roth, so I did a little bit of that. Yeah, and perhaps I will introduce you
I had a birthday.
And our Swiss chocolate.
Katharina Kanarik, I'm a PhD student here at Haifa University and at the Bundeswehr University in Munich, and also political science.
Nice. What's yours?
Yes, thank you. Okay. So, yes, so my presentation is based on my dissertation that I wrote about the case of Tali Fahima. And this is part of a larger project that does analysis, that analyzes what constitutes treason. In my dissertation, I do also social analysis. I look at the media coverage of this case. And here, what I chose for the presentation is part of my legal chapter that deals with administered detention. The larger legal chapter follows the trial until the end, throughout the accusation of treason, and then also what she got at the end, and does an analysis of that. And for this chapter, and partly for this, I used the legal documents from the legal hearings, as well as protocols, interrogation protocols, and I interviewed Fahima, this lady, her lawyer, and other people that were involved in the case. So, yeah, and what I'm doing here is I'm trying to delineate the tensions and the perils of the use of administrative detention for the rule of law. And I used the case of Tali Fahima, which I'm going to talk about her case in more detail in a few minutes. She was the reason I looked at her case is because she was the first Jewish Israeli woman against whom administrative detention was used. And what I'm doing at her case, I don't want to put a bit of an outline here. I'm not looking necessarily at the laws and at the legal structures, but I'm doing some sort of a legal archaeology of her case. So I'm digging into I'm doing a discourse analysis and close reading of the language that was used by the judges. And it's also based on, again, the protocols. Not all of that is here. To see how her dangerousness was decided and how she was, this whole thing was justified. And also the importance of this is that the reason I looked at this is that what happens, the question I'm asking is what happens when you have a Jewish Israeli woman that is entering this whole security paradigm that was mentioned here, and not a Palestinian terrorist that already has, or somebody that already has a background that casts them as dangerous. So she actually, they had to, it was very unintuitive for her to be seen as dangerous. Lastly, this is a works in progress. I published about her in the context of gender. I compared her case to 3 other Israeli cases. And I would love to get journal suggestions because I would like to turn this into a publishable piece for journals and any ideas or yeah. So basically I will start with her case. Yes.
No.
Yes, okay. So this is her. I chose this on purpose. One of the iconic images that when her case broke out was everywhere. So Tali Fahima was born in 1976 in Kiryat Gat, which is a town located in the south part of Israel, which was populated by poor, working class Jews of Middle Eastern descent mostly. Today also Russians and Ethiopians. And until the late 1990s, Fahima led a normal life, typical of many Jewish Israeli women of her background. She was basically right-wing. She voted for Likud, for Ariel Sharon. But all of this changed during the second Intifada, when she told me she wanted to understand why they hate us so much. In the second Intifada, there were suicide bombings happening almost on a daily basis in Israeli cities. And what Fahima did is he started contacting Palestinians and Arabs via the internet chats and forums, and she wanted to know what was the cause of the Palestinians' anger. Such contacts are not illegal in Israel. Yet at the same time, she was summoned for questioning by the Shin Bet, and after they verified that she was not acting as part of a group, they let her go. And by the way, I have to say that having Ami Ayalon's presentation here last week was, and the things that he addressed and not addressed, and he was extremely useful, I think, his background for this presentation. So in 2002, during the second Intifada, Tali Fahima came across an interview with Zacharias Baby, who was the head of the Al-Aqsa Martyrs Brigade in Jenin, which was basically a Palestinian armed resistance group, part of the Fatah. And they were in charge, or they took charge for quite a few suicide bombings that were taking place in Israel. When they spoke to Palestinians about him, they said, well, if he shot someone, he has to leave that and portray himself as a terrorist. So it's very dubious as how much he actually did or not. And Fahima, after she read about him, she contacted the journalist that interviewed him. He had a very interesting life story. His mother and his brother were killed. His mother by clashes. He said the IDF fire killed them. Of course, the army says the opposite. And basically, his mother ran a peace theater on the roof of their house. So very interesting. He was involved with that theater. Very interesting character. All of his friends that were with him in the peace theater, they all died and were all killed by targeted assassinations carried out by the Israeli army. I'll talk about that. I go into that more in the dissertation, but not here. So after they spoke for a while, Fahima asked him if it would be okay for her to go and visit him. He said that yes, and they arranged for her to go and visit him in Geneva in the second Intifada, and when a friendship formed, and she also wanted to start following this visits. She wanted to start after school program for computers. And in one of her visits, she witnessed an attempt to kill him, to kill him. And Fahima felt after that in order to protect her new friend's life, she would basically go and interview an Israeli paper and say, look at what's happening in the West Bank. And she was sure, in a very naive way, I would say, that this would change the Israeli public opinion. And indeed, on March 18, 2004, she gave what I call the Human Shield interview. And so this, you see, this is her and him. Here, there's a photo of her and Janine. And this is her after her conversion to Islam at the end. But, I'm sure you've all read the paper, so you know that this is how she ended up, but I'm going to talk about this toward the end. And basically, so that didn't happen. After that interview, on the contrary, she was fired from her job. She was in Israeli society, she was like, there was a whole basically campaign against her, but she was kept held for interrogations again, and afterwards, she was also placed in house arrest. The Shin Bet didn't know how to place her. It's very important to say that because she did not meet the profile of a regular left-wing activist, her poor background, her Middle Eastern origins. Her parents are from Morocco and do not fit who usually is an activist. Was usually an activist, and basically on May 2004, she was detained for interrogations on her way out of Jenin. Afterwards, she was released for house arrest, and then when she went out, she went to her last visit in Jenin, where a very important incident happened. The Operation Crocodile Tears happened in Jenin, where basically the IDF went into the camp and lost a high security document that contained a map. I'm going to show that. This is the document that was lost. This is the Crocodile Tears. So what was lost is this. So here we see 4 faces of 4 wanted men, as their names. I'm going to translate quickly what day they were born. The year, this external description, and what kind of weapons they were carrying, and if any of them have an ID number, then their ID number. So that was one part, and then it was also this map of a few pages of an aerial map of Geneva. And yeah, so the document reached Fahima's hand, and not Fahima, sorry, very important. Zubaydi's hand when she was with him, and 2 Palestinians that were there with them later testified for the Shin Bet and the court, and said that she helped. First, they said that she helped them translate the document, and I will leave it to you to see if there's anything to translate here. And then she was later accused and found guilty of reading a map. Even, and I will quote from what the judge said or not, but basically the judge said, I think it's not here. The judge said that even if she was not, there was nothing to translate, even if she had no military knowledge, all of that is not important, because what we would expect from a loyal Israeli citizen is to basically get out of there as soon as they can and report. So, yeah, so Fahima was detained on her way out of Geneva after this. She was arrested, and she was held in administrative detention for 4 months, and only after it was changed for regular detention, when she was charged with criminal indictment, that was basically assistance to the enemy in times of war, providing information to the enemy for their benefit, contact with a foreign enemy agent, possessing firearms, and support of terrorist organization. I will note that for assistance to the enemy, it's part of the treason offense. It's one of the 2 offenses in Israel that one can get the death penalty on. And actually, the judges at the beginning of the trial asked the prosecution whether they intended to actually ask for that. And in Israel, only 1 person was executed. It was Adolf Eichmann. Yeah. So.
But not under this law.
I'm sorry.
Not under this law.
Under the other law, of Nazi, under this law, not exactly this law, before the state was started. In 1948, Meir Tobiansky was executed, but that's a whole other story, so I'm not going to get into it. It was, yeah. So yeah. So what is, how much time do I have? Right? Let me just say that this whole thing of asking for the death penalty and so on, or inquiring about that, and administrative detention ended up with a 3-year jail sentence that Fahima got, that included in it her house arrest and her detention itself. And after she was released from jail, she moved to the Arabic village Aran in Israel, converted to Islam, moved to Ramallah, and now she's back in Israel, lives in the village Amirim in the north, and with her son. So, yeah. So a little bit about administrative detention. I don't know. She refused to talk about that. Different thing. I just finished writing a paper about the gender aspects of her story. And yeah, I don't think they. bracket. I don't think they have enough hair. There anything something with someone out there, but yeah, or at least that's what she said, insisted on. Okay, so administered detention is a preventive measure that is meant to stop future atrocities. It is initiated and controlled by the executive branch or by the military, and it is designed to control the potential dangerousness of the detainee. Unlike criminal detention that requires the state to show evidence and press criminal charges and to prove guilt, administered detention does not require all of the above. It is an extreme legal measure. It infringes on the right of due process, separation of power, undermines human rights, IHL, a whole bunch of things that, yes, I'm not going to go into that. In the U.S., we know it because of the use the Americans do it. Use in Guantanamo, and basically in Israel, despite all of the critique that Israel is getting, actually here Palestinians are standing for the Supreme Court, unlike the United States. So here they can actually appeal on their detention. The thing is that it is expensive, it's timely, not everyone can afford that, and yeah. Now, what is going on here, because of the reliance of the classified evidence, there is it creates a severe imbalance between the detainee and the state, as I'm going to go into that. Proponent says that, yes, you do get judicial review, but as we saw with Bainish, the head of the Supreme Court, she said that, yes, we are critiqued for not overturning almost any administrative detention. Until 2007, as far as I know, no administrative detention was overturned by the Supreme Court. So we have here a legal tool that is basically a judicial review that is basically used more as a warning and as for Shin Bet personnel to bring up enough evidence, but it's never been overturned. And yes, and also judges themselves are not immune to public opinion or to times of panic. So when you couple that with the secrecy, we see likelihood of targeting the rights of minority groups. Again, something I'm not going to go into that I expanded. So also we know when the state of Israel existed under an emergency legislation, administered detention in 1976, I believe, or 79. Thank you. Basically was ratified into a regular law, and yeah, but that did not really change. Now in Israel, also the regime, the legal regime I'll be looking at is the one that applies to Israeli civilians. There's another legal regime that exists in the West Bank, a military regime, a legal regime. I'm not going to talk about that here. And I will say that the Israeli Supreme Court said that administrative detention, AD, is necessary evil, and the legal test that they suggested is proportionality, and between the forbidden acts of the individual and the measures adopted by the government. Okay, so how is Fahima assessed as dangerous? This is fascinating, and also looking at what was discussed in the courts and what was not what did not make it to the courts. And it's even more interesting when I looked at what made it to the media, to the Israel media at the time. So it was like chopping down narratives of facts. So, as I said, it's administrative detention is used when a person is considered to be dangerous. It is assessed on future predictions and situations and behaviors that are difficult to anticipate beforehand, especially in the case of such a woman that there was no one like her before that. So it was completely up to the interrogators. These are fluid assessments that provide a space in which ideological beliefs and internal politics shape the understanding of permitted and safe acts of dissent are demonstrated. So as I said, on August 9, 2004, Fahima was detained for questioning. The police was not able to produce enough unclassified evidence to press criminal charges against her, and since the security services said that it was necessary to hold her in custody for further interrogations, the Israeli Defense Minister decided to issue an order for administrative detention for a period of 4 months, and she stayed in administrative detention only for 4 months. Yeah, so during the court sessions, Fahima dangerousness was analyzed based on classified and non-classified evidence and the testimony of a person called Oren, the security agent in the case. The prosecution, and now I'm going to go to quotes from the legal proceeding themselves. So the prosecution was certain of Fahima's intentions and future dangerousness. They were sure that she endangered public safety, state security, and as I'm pointing out, administrative detention, they say, is necessary in this case due to the intent of the defendant to conduct terror activities against Israeli targets with Palestinian terrorists in the Geneva area. It is also justified due to her continuous attempts to get a hold of weapons for these terrorists. She was also accused of conspiring with others to commit a crime, planning an attack within Israel, and violating a military order to enter Area A, which is where Geneva, it's illegal for Israelis to go there. The area is under the sovereignty of Palestinian territory. The prosecutor was also concerned with Fahima's ideological motivation. From the behavior of the defendant, it seems that she has been going through a process of ideological escalation, which caused her to identify with the terrorists so much so that she is now willing to take part in terror activities against Israeli civilians, since hostile fractions are trying to take advantage of her for their purposes without her being necessarily knowingly cooperating with them and without her being aware of this fact. So we have here a double thing going on. On the one hand, classified evidence to which her lawyer does not have access, classified testimony, and her being unaware of being used by the Palestinian terrorists could be, perhaps, who knows, I definitely do not, even after all of this research, but the lack of access to these evidence and to these documents, the classified documents, is, as I'm going to show, proves to be quite dangerous in itself. So Fahima Dangerous was also tied to her Jewish Israeli identity because, as according to the prosecution, according to the determination of the defendant to engage in terror activities, her being a Jewish Israeli citizen might become an incentive for Palestinian terrorists to engage her in her plot against Israelis, which might result in a PR victory both in Israel and around the world. So when discussing Fahima's case, the judges applied what is called the judicial management model, and acted both as lawyers as well as inquisitive judges when replacing the defense attorneys that did not have access to the evidence against her, and that were also not allowed to be present at the hearing of the classified evidence. The district court assessed the credibility of the evidence presented by the security services investigator who testified in the court. The investigation, however, was limited in terms of how much the judges were willing to question the material and the security services that were presented in court. In response to Fahima's claim that the Palestinian sources, namely the men who testified against her, were unreliable since they received money and other benefits for their cooperation, the judges stopped short of examining the credibility of the sources themselves and commented that the Israeli Supreme Court has already referred to this matter and stated that there is no need to express an opinion whether, in a certain case, even the rarest, it will be appropriate for the court itself to assess the source that has provided the incriminating information. In our case, there is no need to address this question, so we see here the judicial management model falling short. And therefore, despite of this accuracy enhancing model of judicial supervision, as it has been called by legal scholars, Fahima case was no exception to all other administrative detainees, none of whom have been released from administrative detention by an Israeli court, at least at the time that I was writing this. The court applied the near certainty exam to assess the magnitude and seriousness of her dangerousness, and concluded that Fahima is adamant in her intent to conduct terror activities against Israeli targets, and to this end, she is also determined to get a hold of weapons from Palestinians. Supreme Court Judge Folkacha is also worth quoting, and her lack of doubt regarding the strength of the evidence regarding Fahima's motivations. She said, "I have come to the conclusion that Tali Fahima administered detention for the requested time is inevitable, since the evidence against her indicate an immediate and clear threat, and if she will set free, she will be set free. She might, in most certainty, be involved in a type of violent terror activity against Israeli targets and Israeli civilians. The evidence I have been presented with is difficult and severe. It is based on direct and reliable sources, although not clear what they are. It reflects the recent extreme radicalization of the appellant and the existence of a direct and immediate threat regarding execution of her intentions. Should be released from custody." So the Supreme Court also had no doubt regarding Fahima's future intentions As they said, the evidence does not allow for any alternative other than isolating her from the public for the period mentioned and the administrative detention warrant, to ensure that under no circumstances will she be able to realize her intentions, which are in line with direct and immediate threat to human life. However, as harsh as these words are, not all judges were so sure. The district court, on the other hand, unlike the Supreme Court and unlike other district courts that dealt with her case, she was judged in Tel Aviv. They said that she must be kept in detention, but they offered an alternative of house arrest. So, lastly, it is important. I would like to, lastly, it's important to mention how the two witnesses on her part. One of them was a previous Israeli member of parliament, Hashem Reed, an Arab Israeli parliament member at the time. Sorry, since then he was not. He testified that Fahima approached him on behalf of Zubaydi, asking him to serve as a liaison between the Israeli authorities and the Aqsa Frontier Brigades and to negotiate a peace agreement in Geneva. The second witness was Yusuf Asfour, an Arab Israeli activist from Jaffa, a part of the who helped Fahima raise money for Children's Computer Center she was hoping to start in Geneva. Fahima stayed in his house in Jaffa prior to her house arrest. The court hardly refers to these testimonies, and it's obvious that they are relying much more on what they consider to be the more reliable Shin Bet security experts. Also, the idea of who's considered to be a security expert, who is not, is also a question here to be unpacked. Especially after we heard how there were problems in the southern interrogation, southern interrogation jails, unlike the central. Anyway, that's referring to that presentation. So Fahima, it is beyond doubt that her character baffled the Shin Bet interrogators. Her alliance and what she said, I'm going to skip this for sake of time. She, on the one hand, she said that she accuses Shin Bet of being the real terrorist and the fault of what is going on in the West Bank and the Palestinian violence. On the other hand, she also says that she's not willing to relinquish her Israeli identity. She sees herself back then as part of the Jewish people. She does not want to live permanently in Jenin because they asked her, why won't you move in Jenin? And this, I think, was one of the causes for the request for the administrative detention. And before I conclude, I would just like to mention what was not mentioned in the court proceedings. So the first thing that is worth mentioning are the interrogation conditions that are, and this is based on the protocols that they mentioned that there, and it has, I mean, some of the protocol that I got had a lot of like black lines and some of what was said there. So this fact, so I guess it's okay that the public will know she was tied for chairs for hours. She was not getting cigarettes. She's a heavy smoker. She sometimes did not have breakfast until after the first or second interrogations. Interrogations were from 8 a.m. until midnight many times. And yeah, she was not allowed to see a doctor. A pregnancy possibility came up. There were mentions of she said, and her lawyer as well, sexual harassment towards her. Yeah, so all of this is, the court did not want to address that. Also, what is not mentioned is the whole internal world that was going on in Geneva. Now, undoubtedly, Fahima is a unique character. Zubaydi, I didn't go into this in this presentation, is also a very unique character. And she stepped into a complicated web of fraction fights within the West Bank, and also between the relationship between the Al-Aqsa brigades and the Shin Bet, and she was perhaps used, not used. They were protecting her. They were using her. Not really clear, but all of this does not appear in the court. So what we see in the court is a very clean narrative that takes all of that away, and it is so important to understand what was going on, the motivation, assessment of dangerousness, and lastly, perhaps another explanation of the use of administrative detention that was mentioned in the newspaper article. It was mentioned, Rahima told me that, and her lawyer said that, that perhaps they offered her to be a collaborator, and as a way to apply pressure on her, they said, okay, we're going to hold you in detention. I don't know. Again, everything is classified. It's not clear. And basically, she refused. She told me that she refused to do that, and because she said that they're her friends and she will not collaborate against them. So again, not clear. There is no evidence of that. As Minerva was saying last week, yes, we recorded. I don't know. So this will be on YouTube. So yes, but that's what she said in her attorney. So to conclude, when a defendant is held in administrative detention, the system typically resorts to a digital management model, according to which judges are expected to act as the defense lawyers because they are denied access to the evidence that the state uses against them. In Rahima case, the judges apply this model partially. Some repeatedly stated that they trusted the Shin Bet and simply accepted the organization's suggestion that Rahima was dangerous. Another infringement of the due process occurred when the prosecution and the judges in the case did not operate separately. We see here also something very interesting, that the state operates both as the court and also as the security apparatus, and we see a meltdown as the division between the judiciary and the executive branch when all of these discussions are going on behind closed doors, and there's no way of questioning the ability or the credibility of these security experts. The Shin Bet personnel counsel judges on matters of security and the security risk posed by Rahima, and at the same time informed the state prosecution that Rahima was suspect of, therefore heavily influenced in decisions about the charges with which to persecute her. The court hearings took place many times behind closed doors without Rahima or her lawyers having access to them. In addition, because the Israeli press coverage focused on Rahima's marginality and rarely mentioned any of these crucial legal aspects of the case, it's really interesting what the press chose to look at and what not. In effect, it helped perpetuate the Shin Bet central but unaccountable role in Israeli politics and law. And let me also reconcile and say that this is not a unique situation for Israel. Anywhere that administrative detention is used, that we know of that it's used, these processes inevitably take place. So the fact that I'm talking about this case as an investigative, as one case to investigate, does not mean that this is something that is unique for Israel. It's very important to mention that. And Fahima's case, as I said to begin with, demonstrates the perils of the use of administrative detention, and it shows what happens when it's used against Jewish, not Palestinian suspects. So when there is heavy media coverage of the story, when there is no, like most cases of administrative detention, go below the radar. Nobody's looking. Nobody is, trying to get the real story or looking at the background. Although it's really a good question. What is the real story? Very little attention was given to that. So I think it's a very good case to look at what happens when it's the most unlikely, undangerous beforehand person that goes into that is being processed by this security paradigm. So that's it.
We have a formal respondent.
Thank you. Thank you for the invitation. Just as a way of introduction, first to say that probably my wife will join us while we are discussing. So I didn't introduce her while I was it's just called Yael, and she was invited to she's living in Israel, which leads me to warnings. The first that I'm not Israeli and I'm not living here, so my knowledge of the situation that is much more yours. So some of my comments would be naive or inaccurate because simply it is not the country I am using, not the country I really know or experience. The second is that I'm lawyer, so it's also an invitation. All come, but it's an invitation. So I had a series of results in this order. I will begin by saying that it's very interesting research. It's maybe quite fascinating, and it requires interdisciplinary skills. That's this. And for me, the two most interesting aspects of the research, not probably perhaps the case, are first, and we mentioned them, two of them. First, the construction of dangerousness by an administrative, by etc. Especially in this case, in the case where dangerousness is not given by the background of the person. And that's, for me, really very interesting. The second point is the construction of the narrative of a judicial or semi-judicial administrative. I've been a judge for 20 years, so I know how judges, not only in administrative detention, I was in Switzerland, you can imagine administrative detention. Last occurrence was in 43. That was. But so I haven't been practicing administrative detention, but I've been a judge. And the way naturally judges construct the narrative of cases, which may be very practical, like more practical this one, etc., is something I have experienced for 20 years. So it's very interesting to really go into this narrative and the way to transform stories into something which can be digested by the judge themselves, and then by the client, and then by the. Oh,
Yes.
Voilà. I introduce you briefly.
Just a fact.
Hello.
Voilà. So yeah, then not a lawyer. So you will find me too much as a technical when I say too much of that. So I was just summarizing, for me, most fascinating aspects of this, the construction of dangerousness, which is more or less a criminological approach, which requires criminological approach. And the construction narrative, where you have to have skills in linguistics in order to see how facts are transformed into a narrative, which is also facts, but facts reconstructed for the aims of being judicial, which is not exactly the raw facts. As you all know, the transformation of raw facts into judicial facts is something I said I've experienced for 20 years, and it's probably the most fascinating aspect of what I've done. Because we really reconstruct something, and here it's something which is very good. Then a second, that's the most at the end perhaps of this remarks, I will express a series of suggestions. First, to say that it's interesting for DRC because we are going directly from Europe, and then from the speaking about Europe, which, as you know, is experiencing something which is quite harsh these days. And the interesting thing is that very often in the media you have the Israeli model, much more often than yes. When I left Geneva, I was listening to France station in France, and one of the main politicians, French politicians, was discussing about the Israeli model, not on administrative detention, but on how do you live with security and with danger. Which is a good thing for France, and they really try to copy that, envisage to copy the Israeli paradigm. Here, naturally, the interesting aspect of this case, not generally the Israeli administrative detention, is the fact that you have an internal enemy, which is also something which is new in European countries, and it's much more widespread. There are a lot of people who are labeled internal enemies because they are French or Belgians born in Molenbeek or Paris, and who are performing terrorist acts in their own country, which is new for a couple of years. It's not. And here, naturally, what you have, your case, with the first Israeli being in administrative detention, is something very attractive, very interesting. Jewish. That's why I say I don't do century. I made a lot of.
This is really, it's identity.
Yeah.
No, sure. But that's my European thing. Kind of nuances sometimes. That's the first comment. The second, more technical, and again, there is no one. If I understood correctly, when she was put into detention, one of the first blames, I don't know if it was in the final judicial decision, is not to have denounced, not to have referred what she has seen in Union as well in the West Bank.
That was at the end of the trial, not at the end of the municipal detention. So, the verdict of the trial.
On the verdict, it's
Yeah.
still there.
Yeah.
And I don't know the legal basis on it, but naturally it's just because I'm writing a small piece on the commission by omission in international criminal law, spoke about international criminal law, and naturally all this question of disputes to act under criminal law or under administrative law are always very open to discussions in that way. So I don't know exactly how it was built in the final judgment, but it's interesting technically. Third point, nothing to do with the previous one. Yeah, you didn't in your paper presentation elaborated in the transformation of evidence brought into a file in administrative detention into evidence used for the aim of a criminal trial. And actually, it's technically it's a very complicated topic, very important in the aspect rule of law or due process aspect of the whole crime. And I guess you will elaborate on it on how do you transform something which brought into the case by ways which are not admissible under criminal law.
That's the second part of the
Yeah.
chapter.
Yeah, I guess. No, but they just mentioned it. One remark on the HL aspect, which came to my mind when reading your paper. An Israeli here is in Israel, not Jewish Israeli. Israeli citizen caught with anti-Terrorism detention is naturally in a different position as the Palestinian caught into detention in situation of occupation. And the paradox is that in some ways, the Palestinian is in a better position, better protected than the Israeli. For instance, cannot be removed to Israel normally. It should stay in the occupied territory.
Query whether that's better or not.
Yeah, okay.
Territory or
Yeah, but
Israel in terms of real life
no,
conditions.
correct. But for instance, for contact with family, if contact with family are allowed, that's the reason why you have it in the Geneva Convention. First of all, I consider only this naturally not the convention. So there are a series of points where. Then two last remarks and then suggestions for elaboration. I was a little bit, to be a bit critical, I was a bit frustrated about the slippery slope because it's in your title. In your paper, I didn't use the fine software, but perhaps in my reading, it appears only once, but only on something which is quite general, the slope from emergency law into ordinary law. So the paradigm of slippery slope, which is in your title, what drew my attention, has not been, in my view, elaborated in your for the moment in the presentation in the paper. So if you have it in your title, naturally the reader is expecting something of slippery slope, and perhaps there are questions about the labeling of the person. There are a lot of approaches of entries into the slippery slope. But frankly, on your paper, I don't find the slippery slope paradigm. And last point, where perhaps you could elaborate, you mentioned it in your presentation, but the proportionality test, and you said something which is quite interesting and probably open to discussion. If I understand it correctly, you are analyzing the proportionality in this very context. The PR aspect of the whole operation from the side of the person submitted to administrative detention, but also from the side of the administrative bodies. Do you accept legally to enter this PR aspect within the discussion on proportionality, has it been introduced in the discussion on proportionality by the deciding bodies, or shall it be more only legal elements which enter into the discussion about proportionality? I don't have the answer, and I don't know if something is just or unjust, accurate or not inaccurate. That naturally is very important, because if you put the PR aspect into this discussion, naturally the proportionality test will lead to completely different outcomes. And I don't know. Again, it's not a closed question. It's really not a closed question, but it's something which raised my interest when you discuss in your paper, but very briefly, and again in your presentation about the proportionality test. So it's naturally very interesting. And it's full of information, and I'm afraid that it will be, as I said, used as a quote-unquote Israeli model with administrative detention, not to follow the discussion in France, but with the presidential elections which are coming up, they are from the party which very, very likely will win the election, whatever the person, but the party with the right party. You have proposals which go far beyond even what the US administration has put in place in 2001, far beyond what you had in what you underlined in your presentation, with judicial review, with all the aspects of which all the limitations of judicial review. But I'm not impressed by the figures. 97% of the proposals by the prosecutor or by the administrative proponent are accepted by the judges, very close to the figures you have in our normal judicial act. I made the research because it was interesting for European comparisons when Italy has completely changed its criminal procedure and introduced a better judicial review of the decision on detention. And after a couple of years, the outcome was in 95%. It's not 100, but 95% of the cases, the new judge, had approved the proposal. So 95% in reality detention was decided by the prosecutor. And the one aim of the system was to change this proposal. So naturally the judicial bodies mean, especially in this case, to follow the proposal, whatever system you have in place. Voilà.
You want to respond or?
Yeah, I just maybe get more comments and then respond. Thank you.
Yeah, one point relates to your last comment. 100% of the applications for judicial review got administrative detention were denied, but 50% of the applications were withdrawn. Okay, because there were some kind of agreement, pre-bargaining, the equivalent of pre-bargaining. I'm just opening it from Haaretz from 2012. So 36% of the applications were withdrawn before hearing, and another 19% were withdrawn during the hearing, which means that actually more than 50% of the applications were accepted. So this is the manipulation of statistics. So I think this is something that you have to take into account. And if you want to argue slippery slope, etc., you really have to examine the numbers, which is also problematic from statistical perspective, from 79 until today. A slippery slope means that if the government has this tool, it will use it more, it will use it in softer cases and so forth. So I'm not sure that's not his case. Supports your case. Now, I'm not sure if Tali Fatima is a really good case for analysis of that. If you think about this, there is no question that you associate yourself with a group that is considered a terrorist group, a group that took militant activities against civilian Israelis. Associate yourself. There is no doubt, okay, that she translated a top secret document classified document?
No. At the court, at the end, and the judicial student said that she did not understand. She read the map, and but even they knew Hebrew. Even if they knew Hebrew, which is what
I'm just saying, in the US, if somebody takes a top classified document, okay, and moves this or uses it or tells about it, you will get to life in prison.
On conference.
No.
Not yet. Not yet.
No. So I'm saying the end result of her getting into prison for 3 years included, deducted the 4 months of prison detention. For what we know about her, a lot of people don't know about her, is not a great case to argue that administrative detentions are the end of the due process and the end of the rule of law and so forth. So you have to be aware that the way that you phrase a cause effect is in a sense a little bit biased because you want to say, this is a horrible thing, administrative detention. And it might be a horrible thing. It is a problematic thing. But I think the most important issue here is the judicial involvement. And again, the important thing is comparative to step. Two things, that everything is done under the auspices of law and not outside the auspices of law. If you compare it to what's happening in France today, when, Article 14 of the Constitution is invoked, and basically the president has unlimited power to do whatever he wants to do without any control. So one thing is that everything is done under the auspices of law, and of course the auspices of law can be very harsh. And the second thing, that there is checks and balances mechanism, and especially judicial input, which again makes it different. And this is the statistic that I get, that 50% of the cases that actually the GCC, the Shinbet, desires to put somebody into administrative detention were not materialize. I think that this is an important factor.
The question is why? Because a lot of times the deals are cut and or are made and for giving out information on other people or whatever it is, and we don't know. The lack of transparency. I have to respond to this.
I accept this, but I'm saying you have to present your case in a more kind of even way.
I will definitely.
And I'm not sure that the Tali Fahima case is a great case for the attack of the whole mechanism of administrative detention in Israel and the way that it's been utilized.
As long as we're in the process. I want to connect maybe the two interventions that we've just heard. First of all, I want to congratulate you on undertaking this endeavor because I think it is important. I think very little, if at all, has been written about it from a scholarly perspective in Israel. It says something about us. I don't think it's a unique case. The question is, what is your main thesis? I tend to agree with Eli that the issue of administrative detention per se, for us lawyers, and we are limited as lawyers, is not really anything that is more or less problematic than any other administrative detention. In fact, some of the administrative detentions of Palestinians, which we take for granted, the Palestinians, and therefore, lasting for months and months and months with no end. Because administrative detention, the problem with administrative is it is endless. It can be renewed and renewed and renewed, provided that the Shin Bet produces evidence of dangerousness. It can be renewed, and there's nothing you can do about it. This is why we have the hunger strikes now. Because people say at one point, Palestinians say, I might as well die because I don't, I can't see the evidence. I'm told I'm dangerous. There's no way out of it. As long as I become a collaborator or sign something that I no longer believe in the Palestinian struggle, whatever, which I'm not willing to sign. And that's it. Good luck. So at some point, they say, okay, I won't eat anymore. So administrative detention is really, really problematic. And in that respect, Al-Fahima is just a piece of the puzzle. So it's a friendly amendment. I wouldn't necessarily place the brunt of your argument on admitting to the detention and the role of the court as a quasi defense attorney versus, because this is inherent in the structure. So the entire, either you like it or you don't, and in the case of the Fahima is important. However, I do think that there are two really interesting contributions in your research. One was touched upon, and that is the construction of dangerousness and the notion of proportionality, whether public perception, I would turn it from PR to public perception, so PP, whatever that may mean. So the question of what the public will take from it, whether it should be as part of that's from a legal point of view, a purely legal point of view, that's a really difficult problem. Because to the extent you open up this manipulable variable called how the public will perceive, and you enter this into proportionality, then who knows? On the other hand, if you ignore it, government will say, or the administration will say, hey, this is what this case stands for. I face the real risk that there will be a new wave of whatever, and that is in part determined on how the public perceives it. So it's really difficult and interesting. So this is I concur. I think the other element is to tell the story not as a normative critique necessarily of administrative detention, but just as the possibility of two narratives: the judicial narrative and alternative narratives that will not disclose. And then you may remain, and I agree with that, you may remain an innocent bystander, just observing without being normative in the sense of Talib Fahima was this or Talib Fahima was that. I tend to disagree with respect to the seriousness or severeness on a substantive level. I think what she did was judged harshly by the security establishment and by the court in terms of the actual military this, that, or the other. That's neither here nor there. The question is that there was an alternative narrative to be offered to the Israeli public, other than the judicial narrative, or the legal narrative, and it would be really an interesting article from an interdisciplinary perspective to say, okay, I'm not telling you anything about, I don't know how judges actually constructed the narratives, I don't know what went into close the other, I don't know. But here's the evidence, and there's this narrative, and there's that narrative. And now she's living in Amirim with all the near certainty that she will do this and do it. Now she's living in Amirim. So maybe she's living in Amirim peacefully because she knows that just like that, the administrative detention is out there, and all that somebody needs to do, the Shin Bet, is to say, hi, Talib Fahima, it's been a long time since we passed net. And that's about it. She goes back to the because judicial supervision is so light. So she's being kept in her place, maybe. But there's an alternative narrative here, and that is that she was being used for PR purposes, identity maintenance purposes. This is us versus them. She crossed the line. This notion of treason, which you can develop, I mean, it's so rich.
I just finished an article.
Okay. Okay, so this idea that the reason why she was so dangerous, perhaps, I don't know, it's a hypothesis, is that she crossed so many identity lines, identity circles. Is that like, for us to maintain the us and them, we had to react.
I disagree with you.
Okay, that's.
By the way, Amirim, for those of you who don't know, might be the most beautiful village in Israel.
We know. We've been there a couple of times.
Okay.
Yeah.
I agree. On this, I agree.
The way I see it is that the treason element is such that you cannot ignore the fact that she associated herself with Weber, that she even had a romantic relationship with him. There was a map that said secret, not top secret, secret, which is a routine thing on maps. It's just maps do not go out with Okay, it's not simple. It's all maps out. And it was so many circles that you have to react. But that's in terms of narrative, construction of identity and narrative. So it's a different piece. It's a piece of society rather than actual administrative detention analysis.
No.
Yeah, it's a different perspective. I was just interested to also see or to look into it, how she was pursued on the Palestinian side, like what the PA wrote about it, like what was like what the people or political leaders in Geneva said about her, if she was maybe pursued, even that they don't say she's like fighting for our case, but maybe she's like sent by the Geneva, maybe she's a double agent. So I think like also for continuing your work, or because you asked for like an advice for where I can publish it in a journal, this would be a very interesting comparison. It's nothing to do with the legal cases, but like how like such a figure is like pursued on two sides, and like what are the different perspectives.
Well, thank you very much for the comments. And yeah, treason is definitely is the main lens that I'm looking at her case and comparing it to other cases. And the whole identity politics definitely is very important. One of my arguments is that if she would have been not Ali Prima from Kiryat, but rather Ashkenazi from Tel Aviv, it would have been a very different case. Also, she would have had.
But Udi Kare, what's his name? Udi Kare?
Udi, after served in jail, he now teaches at the university.
That's fine, but he was like.
Yes, but he also repented and yeah.
He was not free.
No.
He was a kibbutznik, so.
The elite, yes, definitely, and the whole identity politics is playing there also, but in a very different way because it was so. Yes, but to go to your point, yes, I did interview. What you're saying, there's a problem with access. I cannot enter Geneva legally. I entered once before the interviews there. Yes, the first thing that when I spoke with the vice governor of Geneva, that was my host, he said, "Oh, we didn't think she was a Shabbat." And of course, she was not. They were not together. They were not a couple, which of course to me as an indicator that. Well, of course, you thought that if you mentioned that these are the first things. So yeah, there was a lot of suspicion against her on the other side. They also didn't know what to do with her, but I think it's very interesting to see how she was perceived and how he was perceived. So here we have a whole gender lens regarding her, regarding him, who is allowed to cross which lines.
It's super interesting. Thank you so much. It's a very multi-phase kind of criticism, this case of Tali Fahima. If I understood properly from your paper and your presentation, you attacked it from different legal perspectives, both the judicial review, the rules of evidence, the question of gender, the use of administrative, and so on. So my advice, if I may, or to make it more analytically sharp, kind of, is maybe to attack it slightly separately and not altogether. Because, for instance, from the point of rules of evidence, you mentioned the fact that some things were admissible, but the court did not take account of it. But only on this point, taken separately and outside the broader framework, I would argue against you that the rules of evidence in Israel place few limitations on admissibility and leave quite a lot of room for discretion and rules of evidentiary weight for the judges. So on this point, I would, for instance, argue against you. How is it different than any other procedure under Israeli rules of evidence, strictly speaking? So perhaps a good way to go about it would be just kind of maybe through titles, separate titles. This is a criticism from this perspective, so on. On the point of slippery slope, and because, as you mentioned, she's somewhat of an outlier or an oddity, I don't know. I am from the camp that considers slippery slope to be a logical fallacy. So the easiest way to go with slippery slope is just to say prove it. And the answer is you never will. You never will be able to show a direct correlation between A and B without opening yourself up to criticism that in the throughout the years, there were different factual circumstances that changed and so on, and this isn't a special case, and that's a special case. It's very hard, I think, to build this linear connection, so maybe go without. Just don't open yourself up to this at all. And finally, I wonder, on the point of gender, Katerina's question, to the best of my recollection at the time in Geneva, she got it bad on both ends, because in Israel she was perceived as, I'm trying to think of a promiscuous woman, let's put it mildly, or a Michigan at best. And
a relationship with an Arab man.
But particularly because she was a woman who allegedly dared to bed with a Palestinian man, and on the Palestinian front, if memory serves, she got the same way, but with the Jewish caveat. She was also perceived to be a promiscuous Jewish lady who came to. So I wonder. If you may elaborate, if I may ask you to elaborate, do you think that this would have been differently? Because on the point of, for instance, accusations that she made on sexual harassment, well, Irani made similar accusations, and so are the current, or maybe not no longer current, detainees in the Dawabsha incidents. Everyone makes these accusations, and they may be 100% true in all cases, in all counts. And I wonder, where would you draw the line? Where does gender make a difference? Is this on this point, on the public perception point? Would she been treated differently, not only as Ashkenazi or Mizrahi, but where she been Tal Fahima, who came to be BFFs with Kara's baby?
Yes, it's sorry to sound redundant, but first thing I said an article exactly doing a gender analysis of the story, and yes, she crossed so many lines in terms of her relationship with an Arab Palestinian man, terrorist. Also, she brought another narrative, going back to your comment on of the security, of who is safe, what is safety, because she went during the second intifada to Jenin, and she was safe over and over, and this master terrorist was protecting her. So how could this be? And she crossed the checkpoint dressed as a Palestinian woman because she was concerned about the IDF soldiers, not about the Palestinians. So she turned on their head, so many assumptions in Israel regarding security. And again, I want to bracket or qualify all of this, that going through a lot of the protocols, and there were real dangers there. Yeah, these people, there were explosive labs in Jenin, money was transferred from Syria to these. The idea was to kill Jewish Israelis. That was the target. So she was navigating and all of that, being safe as a woman. Also, she overturned or subverted so many assumptions regarding what it means to be a good Jewish Israeli woman, as the Shmita told her, you're going to leave here once you'll be willing to be a good Jewish Israeli woman. Also regarding motherhood, who she was protecting, right? Who she was shielding. She was shielding this with a human shield. Shielding a Palestinian terrorist, not a Jewish child. So a lot of things. The gender point is, yes, very unprovable, but if I use gender constructions to understand what was going on here, or a narrative to perceive her as dangerous and as subversive woman.
If I may ask you a follow-up, do you find any lines of similarity between the way she was treated back in the day, both by courts and by press, with the way Edward Snowden is portrayed in U.S. media?
I didn't follow the Snowden case to such degree that I can. But yes, the idea of treason, and going back to Anna's point, is crucial here. But because she's a woman, she betrayed a whole other set of norms and values than Snowden did. So he was treated as much more as a professional, while she was treated as how do you say, Isha Satan? A deviant woman, a deviant, a seducer, seduced. With the whole thing of the attraction and what does that do when that comes into play. The witch. The whole. I did also a media analysis of the press coverage, and it's fascinating to see how even in Ha'aretz, the lefty newspaper in Israel, still they continuously said that she was her partner, her boyfriend. She was his partner, his boyfriend, his girlfriend. He was her boyfriend. Like, this narrative was continuously circulated, despite, and I think because she refused to talk about it. She never denied it. She said, it's none of your business. I'm not going to go into that. So, putting the border between the public and the private sphere and saying this is the private is also touched a lot of nerves. And last thing to say, and then I want to hear more comments. This is why it's very important. One of my arguments is that her trial was a show trial, in a way, and what they wanted to show is what happens to Jewish Israeli women who crossed the lines like that, because she was not the only activist that was doing that. What the state, Israeli society. I'm using here as a
Should have been a long trial.
and
You
it
said
was
it was a very short trial. If it was a showcase, educate the Israeli public.
the media coverage was for about a year of this thing, and they really made sure to, you have here a few courses that were working in parallel and that the whole idea of Israel nationality and what constitutes the loyal citizen and the loyal citizen who's a woman and the Jewish loyal woman. So, yeah.
If I may, what I was trying to get at previously, it's just be very clear on your postulations and underpinnings. If you assume that a trial should be long, say, I assume that in such instances a trial should be long for this reason, because
I never said it should be long.
First of all, thank you on the presentation. It's really interesting. Two brief questions. One, and that's to counterbalance Amnon. I think that the strongest element that you have with regard to judicial review is the fact that it's theoretical. Because the third time that you come to the court, if all you have is the same evidence that you had the first time, your case becomes weak. And therefore you have these cases, I agree that you have these cases that are endless, nearly endless, but most are not. And from you're actually not confronting the judge per se, you're confronting the theoretical review. Meaning you know that in 4 months you need to prove a stronger case, and in 8 months an even stronger case. In your case, as long as the person is detained, is becoming weaker because his contacts are becoming older. So that, I think, is an element that is really important in maintaining some kind of justice or procedural justice in administrative detention. One comment regarding the presentation, I feel both with regard to the normative elements and the more sociological elements that you are sometimes pushing the case too hard, to the extent that you are it's like if you would give a bit more weight to the other side argument, your argument would become much more convincing. And it's both with regard, I felt it both with regard to the argument on administrative detention. It's much stronger to argue, yeah, I'm aware of all the benefits, but look how it is run in practice, and therefore it's hard. We cannot, the balance the balance between the good and the evil is simply skewed, then to push only the evils, and then you get a counter reaction. And it's the same when it came to the issue of narratives. Narratives are always iffy, always murky. It's not that the state made a show trial and so on. Israeli society does not work that way. It's something that is more in the subconscious. So an acknowledgement of the fact that it's murky, it's subconscious, and so on, would make your argument much stronger.
Over. Try to be brief. It's not the first time for snap. I'm not the one who ran this major detention issue. As to the map, I have to say that during the target of an operation inside such a camp like Geneva may be considered a bit dangerous on real time. That's another issue. I did not deal with the prosecution as the security risk is something that I did not have something to do.
And I did run some administrative detention prosecution and military prosecution. So wherever I'm
They
facing,
had, just look at the comment. They had the van.
yeah.
They knew Hebrew. They didn't need her assistance.
I'm not addressing this whole situation. I'm addressing security risk and this that derives from the situation.
No, but it's important to say that they had it after the operation ended, and the judge acknowledged that she could not lead it because she didn't have the legal training. So the fact that she was flying,
I'm not.
how do you know? Like,
I'll
it's an assumption.
spare me
The judge didn't say that.
the details here. First of all, I remember them vaguely, and then what I remember and what I've done in the prosecution, it's only the question of being the legal advisor to the Israeli intelligence at that time. The security risk of such a map getting lost may be
And the soldier who lost it went to jail. Because an Israeli soldier lost it.
and it's not something very easy to do for a soldier during combat. It's something you don't throw into jail usually. Okay, so that's small. That's not the main issue. Wherever I've already talked briefly. Wherever I'm put with the military, with the detention, the dilemma, I always ask, okay, so what are the alternatives? Okay, that's a very important thing. When you put something and you justly say it's very dangerous, it's slippery slope. I agree there's a danger of slippery slope in democracy for such a terrible tool. It's a terrible tool. For a lawyer, it's a terrible tool, and like using it. The question is always what are the alternatives, and you have to. And I suggest you. Being practical, that's what I would suggest to you to go further with. And the other thing is when you try to present the narrative or compare the narrative to other cases, it came up here. It may be a very unique case, but it's very important to show the comparative side of it and to prove the point. You may have a very good point here. For example, on the other side, as someone who read lots of logs of judgments or the court rulings about the military on administrative detention. First, the rhetoric here, the judge's rhetoric is very detailed. One of the most detailed verdicts I ever seen. Almost revealing. I would say I don't know. I did not run this administrative detention. It may not reveal anything, but it's very detailed. I almost never see what does it say. It's very harsh. Even comparative, when you take other judgments, other rulings, it's very, very, very harsh. What does it say? I may say good or bad things, I don't know, but the comparative point is very, very important, and I suggest you to do it. It will add, and I respectfully concur with what Viv said, it will add to your making your point that you're trying to make. I'm not speaking only from this case.
I'm going back to something which you've written, but mentioned to me the performative aspects. Now, if I think of the judiciary, my point of view as a political scientist would be that it's supposed to follow procedure. They're supposed to be mindful of the conditions. But when it comes to a judgment, it should reflect the facts rather than political considerations. But if you look at the wording of the judgment, now my question would be, do you think there is a politically performative aspect to it? Especially if you think about the role of the media. Did the judges actually think about the impact that the wording or the kind of revelation they might be making in a judgment would have an impact in the public realm? And if, well, to what extent would they? is that because if you go into discourse analysis like really deeply, we start reading lots of things into narratives, and we start thinking about intention in a way I think even a particularly mindful judge might not think about. You know how discourse analysis just it gets really, really, really deep, and it starts becoming very interpretational, and I'm just wondering whether interpretation might actually go beyond the conscious mindfulness the judge puts in.
Of course. I mean, I think, I don't know how much they thought that somebody would go through the decisions and, and comb through it and take out the wording. And I think that they truly believed at the time that she was dangerous, and that they were also very angry at her. You can see that from the language, also in Hebrew. Yeah. So, and your question is,
if they do think about the political implications, does that?
For that, I would have to interview them. I don't know if they thought about the political implications or not, but what I did see is how this was received in the media, where this was taken, and how this was covered by 3 main newspapers in Israel, the 2 mainstream ones, and the one that's a little bit on the left, and occasionally also the right-wing one, or the right-wing one. So, yeah, so what happened to these court decisions when they were revealed to the public? Not much, not much. They mostly relied on interviews. They mostly relied on going over and over on her background. A lot of interviews with neighbors, her parents, her mom, basically. Yeah, did you say how much the judges were aware of it?
Yeah, I'm just wondering on the sort of relationship between public opinion and the actual proceeding, because
I would be also very careful from saying that her identity influenced the harshness in that, or her being a woman that is going over to the other side. Would it be different with the men? I think this would go into speculations, which I don't want to.
That note, let's not go any further. Very uniquely, we were right on time. So I'm going to stop here and thank you. We're going to take 15 minutes break. And then